Hello, everyone. I'm Sara Raney. I am not an attorney, but I am a victim. I lost my son, Kenley Raney, on January 25th, 2019, to a drunk driver by the name of Dennis Rodriguez Abeda Jr. Now, I can say his name because I finally got him in prison. It took me many years to do so, but I did. Now, through the trials and tribulations, red tape, and the nonsense that went on during the last few years, I learned a lot. And I can tell you this much. Reality is much different than what we see on TV. It's much different, and sometimes very surprising. And one of the things I found that was surprising to me was the collection of fingerprints. When I got the witness list, there were several latent fingerprint examiners and forensic examiners, and I will explain the difference. Now, Kenley's father was a criminalist and latent print examiner. So I am familiar with it, but a little bit shocked as to why it was there. I kept thinking, why would you need fingerprints? When a drunk who killed your child was strapped in driver's seat, upside down, how could a defense attorney find loopholes? But all it takes is one juror to render a not guilty verdict in a jury trial, which may be less likely in a bench trial, where a judge determines the guilt or innocence. Now, why would you need fingerprints? Why would you need fingerprints? Well, let me go with this. Kenley's father was a criminalist, latent fingerprint examiner, and an expert witness for both federal and state courts. So I am familiar, like I said before, a little bit with this. But I needed clarification about why several latent examiners were on the witness list, as well as several forensic examiners were on the list. Now, it did not make sense to me as Dennis was strapped in the driver's seat upside down and alone, yelling for help next to the railroad tracks. I understand they had to stop the train that morning for fear it would have hit him. And I just, to this day, shocking. Now, let's talk about fingerprints. Now, once collected, fingerprints must be preserved appropriately. Now, detailed documentation, including photographs, sketches, ensures the integrity of the evidence and is maintained from the crash site in the courtroom. Now, automatic fingerprint identification, this is AFIS, AFIS, is used to compare these prints to millions of known fingerprints in a database. I don't know how many people my husband had arrested that they thought they got away with something years before. Now, my fingerprints are in the system because I was in the Army and I had other positions where I needed to have a security check or some type of background check. If for any reason you've had fingerprints taken, they are also in AFIS. In case of DUI manslaughter, fingerprint evidence can be crucial for both the prosecutor and the defense. And the defense may use it as a loophole. Here's how. Okay? Now, for the prosecutor, fingerprints can confirm the presence of a suspect in a vehicle or at a crash site. Prints on the steering wheel, gear shift, door handles can be particularly incriminating, indicating that the suspect was driving during the crash. But maybe not. I'll tell you about that later. A picture of a drunk in a car at a crash site is not concrete evidence. Just like being drunk and not able to take a breathalyzer test was not evidence in my son's case. I had to get a BAC. Fingerprint evidence can support other forms such as eyewitness testimony, which there was somebody there immediately. In fact, they heard the crash. Or video footage to build a comprehensive case against the drunk. Now, potential defense loopholes. Oh boy. Now, despite the strength of fingerprint evidence, defense attorneys may exploit loopholes to sow doubts. They might seek to discredit the prosecutor's latent fingerprints by uncovering details, including diving into their personal lives. Believe me, I know my husband talked about that. And I just recently went through something with a defense attorney, and I felt the same way. I really did. They went back with my history back to the 1970s. I mean, I'm the victim. I just felt like they were trying to see if I could get confused, or if they could confuse me, which they did. Now, legitimate access. Oh, this is a good one. Arguing that defendant's fingerprints in the vehicle are not incriminated because they had legitimate access to the car, such as being the previous owner, being the owner, or a frequent driver, would naturally result in fingerprints being present. Because at this time, there is no way of proving when a fingerprint was made. Now, here's a good one. You see this on TV. Maybe somebody in the mafia or maybe somebody that had millions of dollars could do this. Maybe. Transfer of prints. I think I just seen this on an old Scarecrow and King TV show. This suggests that the fingerprints could have been transferred from other objects. Now, to me, this is desperation here. The transfer of fingerprints is typically considered a complex and unreliable process, and usually only feasible in a controlled laboratory conditions or on TV. Now, my experience with the defense attorneys is that they aim to confuse, like I said, and create doubt, especially to acquit a guilty individual or secure a reduced sentence. People tend to trust what they see on TV, but that does not reflect reality. If multiple people were in the vehicle, the defense could argue that the fingerprints do not prove the defendant was driving during the crash. Now, I would think that if they're strapped in a seatbelt in a crashed car, that would prove it. And nobody else was in there also would prove it in my case. But that didn't. They needed fingerprints. All this is to create doubt. Doubt. So all it takes is one juror to get a not guilty. Like I said, unless it's a bench trial. I have been discussing independent forensic experts and latent print examiners. Now let me explain the difference, because there is a very big difference. A forensic consultant or independent forensic expert in latent print examination analyzes and compares fingerprints to identify individuals. Now, the defense pays them. Therefore, in my opinion, the loyalty is to the defense. Now, unlike latent print examiner, which is what my husband was, is employed by law enforcement agents. In my case, it was his last place he worked was San Jose Police Department, who are responsible to finding evidence and letting the jury decide whether to agree with it. Then they go on to another case, and another case. Whereas forensic consultants pretty much stick to the same case until it's done. Racking up a bill, I would assume. Forensic consultants are independent experts who work with private client defense attorneys, and private defense typically hire them. Now, challenging the police department's latent print examiner conclusions may prompt the defense to investigate personal life details of the wife, which would be me, or children, or the latent print examiner themselves, to cast a doubt that they are telling the truth and secure a favorable legal outcome for the defense. There's nothing, in my opinion, that a defense attorney will not do to get their client off. And sometimes shady. Incidentally, shady but legal. Incidentally, the independence expert fee can be extremely high, and their job, again, is to discredit the testimony of a latent print examiner or expert hired by the prosecutor. Well, actually, they're not hired by the prosecutor. That's a misnomer. They work with the prosecutor through the local police department. And again, the defense attorney's role is to find loopholes, which I understand is legal, like I said. However, I feel it is unethical when they go to extremes, especially when there is no doubt that the client is guilty, as in my son's case. Now, conclusion. Latent fingerprint examination plays a critical role in our justice system. It helps ensure that the guilty are held accountable and the innocent are protected. Sometimes a loophole allows the defense to cast it out of the jury. Now, defense attorneys can exploit various loopholes, weakness, fingerprints, and evidence, challenge its reliability and admissibility. Below are common strategies they may employ. Quality of prints, arguing that the fingerprints collected could be of better quality, smudged, incomplete, otherwise unclear, making them unreliable or for comparison. Chain of custody. Oh, we always come back to chain of custody. But when a court trial takes 4 years to do, I can see why. Question the integrity of the chain of custody. If there are gaps and inconsistencies in how the evidence was handled, the prints might have been contaminated or tampered with. No wonder there's so many witnesses. Everybody, they have to find people come in and say, no, they knew where the evidence was at. Collection methods. Criticizing the methods used to collect fingerprints. Haven't we heard this before in other things, in blood evidence? The evidence might be deemed unreliable if the techniques were not up to standard and improperly conducted. That is always the excuse in any of this. Environmental factors. Heat, humidity, surface texture could have degraded or altered the fingerprints, impacting their quality. An ability to make an identification. You have to have so many points. And of course, each state, each city, I don't know, it's all different. Human error. Now, yes, there can be human error, but it's highly unlikely. Because you have APHIS, then after they use APHIS, then they go individually. My husband went individually and did the old method of fingerprinting, where you had the little glass and the magnifying glass and checked it. So that, I don't think happens a lot. Subjectivity. Arguing that fingerprint analysis is inherently subjective. It relies heavily on the examiner's judgment, which can lead to inconsistencies and errors. And oh my God, this is something that I think rolls off their tongue about everything for what I've seen. Now, this is important here, like I just referenced before, is the lack of standardization. Yes, it does vary from jurisdiction and forensic laboratories. Now, alternate explanations, such as alternate explanations for the presence of the defendant's fingerprints, such as legitimate prior access, location, objects. Oh, you got it. Cross-examination. You've heard this before when it comes to blood work. However, this is the silliest one, which I just talked about a little while ago, is transferring fingerprints from other surfaces or individuals to the crash scene. It's just not, I don't know. To me, it's just, they'll try anything. And they legally can do it, by the way. Oh, just some get a little bit more shadier than others. Faulty equipment, technology. Another one. Here's the one I really hate, and I mentioned it before. Discrediting the expertise or qualifications of forensic examiners or expert witness who analyze fingerprints. Possibly through cross-examination or presenting opposing expert testimony. I've been there. Now, these are the same as I just discussed in other videos dealing with blood alcohol content, BAC, and I feel like a broken record saying the same things over and over and over again, but I think you can see on TV now with the court trials that this is what's happening there too. Now, by addressing these potential loopholes, defense attorneys aim to create a reasonable doubt about the reliability of the fingerprint evidence presented by the prosecution. By leveraging those potential loopholes, defense attorneys aim to weaken the prosecution's case, introduce doubt about the victim's guilt, potentially achieve a reduction in charges or an acquittal. This is all they're trying to do. And believe me, if you are a victim and you're called up on the stand in a court trial, and you probably will be, they can confuse you too. However, that usually doesn't work because you're the victim, but I don't know. In conclusion, the fingerprint evidence plays a critical role in forensic investigations and the pursuit of justice. It has challenges and loopholes that the defense attorney can exploit, as with everything. By questioning the quality of the prints, the integrity of the chain of custody, and the methods used for collection, among other factors, defense attorneys can create reasonable doubt about the reliability, like I said before. But these strategies highlight the importance of meticulous evidence handling for everyone. But for families affected by DUI manslaughter, Understanding these potential loopholes underscores the necessity of being a squeaky wheel who gets the grease. You have to pursue for accountability for your loved one. You have to be the squeaky wheel that gets the grease. You have to know your rights, and you have to be involved. However, there are some such people that I know that cannot get involved like I am. But I understand that. I do understand that. I am Sara Raney, and I am the proud mother of Dr. Kenley Jean Raney and his beautiful blue-hilled Australian shepherd, Marshall, who incidentally flew 500 feet to his death. I didn't have to go through a trial for many reasons, which I have explained in other videos. But there may be other trials that I have to go through. I do not know. Right now, I am in the process of writing a protest letter to keep Dennis in jail, or in prison, excuse me. This is a life sentence that we have taken on, that we've been given or handed, and it's unfair. It's unfair. But I hope in my son's memory, like him, he always helped. He was a helper and wanted to help everybody. I hope that I can help somebody with some tidbit of information that will help them get through this miserable life sentence that we've been given. Again, I am not an attorney. I am Sara Raney, proud mother and a victim. Thank you.